And you will
Hello,
be.
hello, everyone. Welcome to our webinar today. We are so happy to see you all and happy May 14th, middle of May already. We're really excited to be presenting this with our wonderful partner, ProAssurance, medical malpractice insurance provider. And we are very excited to offer you a great presentation today entitled System Update Required, Managing Risks in the AI Era. This is certainly something that is applicable to every medical practice, every hospital, every solo practitioner out there. So we're going to hear from the expert today. And I would like to introduce our expert right now, our amazing partner, Katie Theodorakis, JD, Regional Manager for Risk Management, ProAssurance. Katie has over 25 years of experience in healthcare risk management, including managing the professional liability program at a large urban hospital for the University of California and working as a risk manager at John Muir Hospital and NorCal before joining ProAssurance. Katie has an extensive portfolio working with physicians, administrators, and other healthcare professionals to reduce liability risk and improve patient safety. She has a JD from University of San Francisco School of Law. And many of you probably have met Katie at our annual High Desert meetings, and Katie joined us this past March, early March, up in the High Desert. So I'm sure she'll be there again. And with that, Katie, we're excited to turn over the spotlight to you.
All right. Thank you so much, Allison. I appreciate it. Let me just go ahead and share my screen here. All right. There we go. And gosh, hearing that bio, 25 years in this business, it's crazy. It makes me feel so old. Maybe I just should say I was a child prodigy. I started when I was 5.
Well,
That'll
that
help.
too. Yeah.
That'll help a little bit. But I am going to talk about AI today, managing risk in the AI era. And AI is here and it's here to stay. I know my personal experience, my husband retired last year, and I wish he would find some other hobby, but his hobby right now is he just listens to CNBC all day long and analyzes the stock market. And yeah, I'm going to convince him to do something else. But anyway, I mentioned that because I could hear the TV in the other room all the time, and all it is AI. AI stocks, AI this, AI that. And so it's here. And I'm going to talk about what AI is, common things we see in the healthcare setting, and also, most importantly, what you can do to mitigate those risks. First of all, as far as CME, this program has been designated for a maximum of one AMA PRA Category 1 credit. You should only claim the credit commensurate with the extent of your participation in the activity. And to receive CME credit, you must complete the post-activity evaluation and attestation survey. And in addition, I do need to disclose that faculty, myself, and the CME planners have no relevant financial relationships to disclose. And you will be receiving an email after the webinar that will have the link to the survey as well as a handout of the slides. And you would just need to complete that survey again to get your CME credit for the program. As far as objectives, you can see them listed there. I'm not going to read them verbatim, but it will support your activity to to describe current trends, legislation, emerging models shaping AI use, recognize the legal, ethical, and patient safety risks associated with AI, and lastly, apply best practices for things such as disclosure, documentation, clinician oversight to reduce your risks. I do need to state a disclaimer that the information contained in this presentation is intended as risk management advice. It does not constitute a legal opinion, nor is it a substitute for legal advice. Legal inquiries about topics discussed during this presentation should be directed to an attorney. Just a little bit of background on AI first before we get too deep into the implications of AI in healthcare, and I'll talk a little bit just about the history of its development. First, it's important to distinguish between common AI-related terms. So AI is a broad umbrella concept. Artificial intelligence simulates human intelligence through the use of software designed to think and act like humans, and it displays capabilities such as learning and problem solving. The first AI program was developed, believe it or not, back in 1955, and this marked the beginning of various specialized fields under the AI umbrella. Machine learning refers to systems that improve performance through experience with data. Deep learning is a subset of machine learning that uses layered neural networks, and I honestly don't even know what that means. So basically, in layman's terms, it's just a whole lot more complicated. It uses these networks to do things such as imaging and speech recognition. And then generative AI represents a newer category, and this is systems capable of creating new text, new images or audio or video rather than just simply classifying or predicting outcomes. And you hear of this, when you hear of the term deep fake videos where they literally can recreate someone, like your boss who can send you a message saying, oh, you need to transfer this money or whatever it may be. And they look frighteningly real. So that's kind of one of the examples of this generative AI. Over the next decade, the healthcare AI market is projected by some to approach 500 billion in size. And with that level of investment, we can expect accelerated technological development and increasingly rapid implementation across clinical, administrative, and operational settings. And this further amplifies both the opportunities and the risks associated with AI adoption. Let's briefly just take a look at the regulatory landscape and how AI is governed and overseen currently. The current healthcare AI governance ecosystem, so to speak, it's really fragmented and multi-layered. Oversight is spread across a combination of federal agency regulations, state laws, executive actions, such as executive orders, and professional organization guidance. So taken together, this ecosystem reflects a rapidly evolving, but still really disjointed approach to governing healthcare AI. Though there's yet to be any large-scale federal legislation on AI, 2025 did see a handful of executive orders aimed at the issue, and many states, including California, are pursuing legislation. While there's no single comprehensive federal statute that directly governs the use of artificial intelligence in healthcare, there's a meaningful, but still fragmented, level of oversight that exists across several federal agencies. First, the Food and Drug Administration, the FDA, regulates AI tools, kind of like software, as a medical device to ensure that they perform as intended and don't propose unreasonable risk to patients. To fall within the FDA's jurisdiction, the software that we're looking at, it must be intended for one or more medical purposes and perform those purposes independently of any hardware or medical device. And there are many AI tools that meet this definition, and they're therefore subject to FDA regulatory requirements. By contrast, some AI tools don't meet this definition. For example, AI functionalities that are embedded within an EHR and that are primarily designed maybe to store, organize, display health information rather than to independently diagnose, treat, or directly drive clinical decision making. So those wouldn't be subject to this regulation. The Department of Health and Human Services enforces HIPAA, which, as we all know, governs the use of protected health information. And DHHS also oversees civil rights laws that prohibit discrimination in federally funded healthcare programs. And that discrimination may result from the use of AI tools. And both of these areas will be discussed a little bit later in the presentation. And finally, the Federal Trade Commission, that has the authority to pursue enforcement actions against companies that make false, misleading claims about AI. This include, I'm sorry? Oh, this includes representing an AI system's capabilities, performance, or clinical benefits, as well as making unsubstantiated health-related claims. Some of the most consequential and rapidly developing regulations are occurring at the state level, and they address key areas such as transparency, bias, accountability, and patient protections. State level developments may help demonstrate both the direction in which AI governance is evolving and practical compliance challenges faced by organizations that use this AI, and especially if you're operating across multiple states. As for California, the California Assembly Bill 3030 requires disclosure when providing patients AI generated patient clinical communications. Patients must be notified that communication was generated by AI, and there must be clear instructions on how the patient can contact a human provider. However, and this is a big however, this disclosure required by the bill is not required if the communication is reviewed and approved by a licensed clinician. So, for example, the medical record notes that are generated using AI, which I'm going to talk about in a bit, those we hope they should be reviewed by a physician before they're finalized. So, that this disclosure under this law doesn't need to happen in that sense, even though there's other laws, such as in California, it's an all-party consent state when we're talking about recording. And this is under a penal code, so it's not directly related to AI, but it applies if you're recording conversations. And so therefore consent is required when you're using like ambient AI to record visits and generate notes. Verbal consent is fine, it does suffice, but the consent should be documented and charted at every visit. If you haven't done so already, an easy tool to use would be maybe a EHR smart phrase that can be generated at each visit that notes that consent had been obtained. And lastly, as far as professional organizations, the American Medical Association has taken a very active and sustained role in shaping policy guidance on the use of AI in healthcare. Central to the AMA's efforts is this concept of augmented intelligence, emphasizing that AI should support, not replace, physician decision making. The AMA adopted its first AI-related policy back in 2019, and it's continually expanded its policies on this topic. And in 2023, the AMA Board of Trustee approved a set of core principles for AI. Now, AI policies, they don't carry the force of law. They're not legally binding. However, they can be very meaningful and persuasive when you're talking about legal and regulatory contexts. And a physician can't be held liable solely for failing to follow an AMA policy, but they can be used, the guidance can be used to try to influence a jury or a court in evaluating the reasonableness of a physician's conduct. So let's just take a look at the current state of healthcare AI. And when I say current state, I kind of say it with a grain of salt because one thing I learned when I was researching this topic and getting up to speed on the webinar is that it changes so rapidly. It seems like every day there's a new development. So that's why I'm giving you just this high level with some recent information, but I can't say that something wasn't issued yesterday that might have additional meaning to this. So that's kind of my little disclaimer. So AI, it's really infiltrated the medical industry. So as of 2024, North America sustained 54% global share of healthcare AI the market, and it's expected to grow exponentially each year. As of September 2025, spending reached 1.4 billion, tripling from 2024. In 2025, ambient scribes garnered the most attention compared to the other clinical AI solutions. And we could expect to see a boom of patient care access and remote features, placing AI in the hands of consumers. And we're definitely already seeing this, such as tools, lifestyle monitoring, vitals tracking, triage for urgent emergency care, scheduling, and follow-up communications. Just here's some stats. And as I mentioned, we're no longer knocking on the door of AI. It's here. That door is wide open. As in September 2025, more than 70% of healthcare organizations around the globe were utilizing clinical decision support systems generated by AI. And faced with this high demand, coupled with physician attrition and burnout, health systems are leaning heavily into AI and AI solutions. 65% of hospitals use AI predictive models. But the great news is these results are promising. With pilot programs, unplanned ICU transfers have been cut 20 to 30%. Patient wait times for imaging have been reduced by 15 to 25%. And machine learning AI is particularly well suited for analyzing large, diverse data sets, especially in applications that require image interpretation. So while radiology accounts for nearly 75% of FDA authorizations for AI-enabled medical devices, radiology is really the leaders in this area. Cardiology is coming in second. It represents second most active area of FDA submissions. So lots of promise in those areas. Now, I do want to talk about ambient listening because, as you can see, artificial intelligence has already had a significant impact on healthcare. But its most immediate and visible effects, experienced both by patients and physicians, providers, are occurring in the area of ambient listening. And for many physicians, this is likely their primary point of contact with AI.
Hey, Katie.
Yes,
Excuse me for interrupting. This is Allison. There's some kind of feedback going on. Is that on your end or?
I don't think so. I don't hear it. Everyone would want to make
Okay.
sure to mute.
Yeah.
If,
Okay.
can you
Thank
still
you.
hear me okay, or is it just kind of annoying?
No, it just sounds like an echo a little bit.
Oh, okay. Okay. Yeah, if everyone mutes, maybe that might solve the problem.
Awesome. Sorry to interrupt.
Oh, no, no, no. I appreciate it. Okay, so ambient listening systems, such as what many of you are using, they're growing rapidly in popularity. So, according to a 2024 MGMA Medical Group Management Association survey, 42% of medical groups are already using this technology. And these systems use, whether it's microphones, cell phones to record physician-patient conversations. And then, as they generate notes and often suggest billing codes. The physician reviews and finalizes the note and then adds it to the medical record. Well, the appeal of this technology is apparent, especially from the efficiency perspective. 2025 study published in Future Healthcare Journal found that clinicians spend approximately 2.5 fewer hours per week doing after hours documentation. And this is a reduction that correlates with lower levels of frustration, burnout. Also, a 2025 study in the Journal of the AMA reported a decrease in burnout rates from ambulatory clinic physicians, and this went from 51.9% to 38.8%. And this followed the implementation of these ambient documentation tools. And as is the case with almost every piece of new technology, promised advancement brings with it new risks to account for it. And a significant risk associated with this particular use of ambient listening, it's the over reliance, or what we call automation bias. And this is the tendency for individuals to over rely on automated systems, even when those systems may be incorrect or incomplete. And a commonly cited example is the over dependence on GPS navigation, where users follow automated directions despite clear real world cues to the contrary. Like there might be a road closure sign or visible hazards. You can see in this picture, the van seeming to be driving off into the abyss. One lesson in my life from several years ago now, but my parents had never owned a GPS device for their car. And this was back in the day before phones, when it was those big, heavy GPS things that you would put on your dashboard. But I gave one for my parents for Christmas, and they were really excited about it. And they decided to use it to take them to a dinner at a hall in a neighboring town. So they put in the address. It got them there quickly. They were very happy with it. They had a great time at the dinner. And then they decided to come home. And they started off, and it took 3 times of going down the street and turning and circling back to this dinner hall that they realized they had forgot to put the home address in there. They had forgot to change the address. But they dutifully followed the GPS directions for 3 times before they realizing that something was amiss. So that's the kind of extreme example, but that's the example of this automation bias where you might tend to over rely. And this automation bias really has the potential to permeate nearly every application of AI, particularly in the tool as these tools they become more accurate and more efficient. Clinicians will grow accustomed to AI system outputs, and there's a risk that critical oversight and independent clinical judgment may gradually erode. So, in the context of ambient AI documentation tools, this risk is especially pronounced. Over time, clinicians may develop increased confidence in the accuracy and the completeness of the notes, leading to less vigorous review and verification before that note's finalized. And this diminished scrutiny increases the risk of factual inaccuracies, omissions, or mischaracterizations of the clinical encounter. Another issue to consider with ambient exposure is legal discovery. And, it's a technical term. Discovery is what you turn over to the other side during a lawsuit. So while clinicians are typically only privy to the generated note, oftentimes these listening systems may also capture and store a raw audio of the entire patient encounter. And whether this data is retained depends on the design and configuration of that specific system. And as such, physicians and practices, you should really work with vendors to determine whether this system stores complete audio recordings. And if the system obtains or retains that raw recording, it will undoubtedly be discoverable in litigation. So you want to know how long are these retained? Are they typically deleted after a certain period of time? Because really, the worst case scenario is that there could be inconsistency between the note in the medical record and the audio recording. And even a seemingly minor inconsistencies could undermine the accuracy and reliability of the record. And we used to see this with even with like Dragon dictating. If it was just kind of a sloppy error, yeah, it might not have caused any patient harm. But if you're looking at the whole record, it just maybe underlies the credibility of the node. It just doesn't look good. And negative optics like this can really hurt an otherwise defensible case. And another issue that needs to be really looked at is the spoliation of evidence. And because these recordings are generally discoverable, you have an obligation to retain them in certain situations. And this is like a duty to preserve when, say, you get served with a lawsuit. If there's litigation happening, pending, then failure to retain these recordings can lead to allegations of spoliation of evidence, which can result in legal sanctions or adverse inferences. And what an adverse inference means is that if someone fails to preserve something that they had a duty to maintain, the jury will be told that they can infer that that evidence that was no longer there would have harmed that party's case. So it's just one other thing that could hurt you. Patient disclosure and consent is another essential component of utilizing ambient AI. Ambient AI tools typically support documentation, workflow, quality, and they rather than just directly delivering medical treatment. So as a result, their use usually doesn't trigger the same informed consent requirements as procedures do. However, there's an ethical obligation, as I mentioned before, too. In California, there is a legal obligation having to do with the recording to obtain consent. Consent can be obtained either in writing or verbally. And according to a 2025 study published in the Journal of the AMA, verbal consent was the most common approach to obtaining consent. Interesting that this same study found that nearly every patient wanted to know more about the AI's data use and their data storage, how it's used, how the audio is used, and who had access to it. So it's important just for physicians, other healthcare providers to know general, high level how it works and be prepared to answer some of those questions if the patients ask them. Posting notices like this one, you can see here in exam rooms where ambient AI is available or is being used. It's really good. It's a good idea because it can provide some of that information to patients. There was a lawsuit fairly recently filed in California. It was November of 2025, so it's still ongoing. It's one of the first examples of litigation linked to ambient listening AI in healthcare. And in this case, the patient claimed that Sharp Healthcare, is down in San Diego, secretly recorded doctor-patient conversations using an ambient AI listening tool without the patient's knowledge or consent. And according to the complaint, the tool recorded entire exam room conversations, including sensitive information, personal information, which was then transmitted to the vendor servers for processing and potential review. Sounds pretty standard. It also claims that patients were never informed their visits were being recorded, nor given an opportunity to consent or opt out, despite California being a two-party consent state. The lawsuit further alleges that the AI system automatically inserted false content language into the medical record, stating the patient had been advised of the recordings and had consented, even when no such discussion occurred. So, this is a classic case of a note going in. Maybe it's a smart phrase saying that consent had been obtained, and it really hadn't. So, I mean, again, it's kind of common sense, but a huge lesson if you're going to have something like that. Uh, if you're going to have, say, something automatically inserted, you need to make sure to do what it says was done. And and this is just, what the patient is alleging in this case. So we'll see what happens when it goes to court. The plaintiff also argued that his privacy rights, California privacy laws, and the Confidentiality of Medical Information Act were violated, and because they require a written authorization before sharing information with third parties. So, we'll be talking about that a little bit more later on about this whole issue of, where that information goes to the AI vendor and whether authorization is needed. Ambient listening, it's likely here to stay. It's already implemented everywhere. And so these are some of the best practices that you should consider. Be transparent with patients, clearly disclose the use of ambient listening or AI documentation tools at or before the point of care, using plain language that explains what the technology does, what it's for, what it captures, how it supports clinical care, and be sure to obtain consent before initiating the recording. Even if patients have previously agreed to use the system, letting them know each time and getting that consent each time the AI system is activated or deactivated will go a long way towards putting them at ease about this technology. And allow patients to opt out. And so if they do choose not to use that, be sure and make sure it doesn't delay or compromise care, and ensure clinicians and staff are really trained on what to do, how to honor that choice in real time. And understand and manage data retention. And this is probably something more for IT, but I think everyone in the practice should have a good understanding of the vendors, the recording, the transcription, the data retention. How long is this data, the audio stored, and who can access it, and when are they securely deleted? And they should be deleted in accordance with the contractual, regulatory, and your organizational requirements in policy. And I just want to mention that we do have a podcast. And if you're interested in implementing an ambient device, if you haven't already, or maybe even if you have, I encourage you to listen to this podcast. And in the episode, as the CFO of a multi-state healthcare organization shares practical firsthand insights into how to deploy ambient AI, how it's been received by their patients and their clinicians, the operational compliance and workflow considerations that they encountered along this journey. So you can, if you want to get right to the podcast, you can scan that QR code. So while there's a general consensus that the use of ambient listening AI should be disclosed to patients, disclosure and consent become complex when the AI is deployed in less visible ways that nevertheless influence care. AI tools may operate in the background, supporting diagnosis, risk stratification, without the obvious patient-facing interaction. And this raises a critical question. How should clinicians approach disclosure and consents when AI meaningfully informs care, but is not directly experienced by the patient? Many of these legal ethical questions in this area remain unresolved at this point, and standards continue to evolve across jurisdictions and with professional organizations such as the AMA and regulatory bodies. That said, there's a clear and growing push towards greater transparency. It's really driven by patient expectations, emerging guidance, and risk management consideration. In this section, I'm just going to look at some of those disclosure and consent principles, which really apply across different AI uses and where clinicians should be thinking proactively, even in the absence of definitive rules at this point. When we talk about patient permission around AI, it helps to separate informed disclosure from informed consent. Informed consent, I know you all are aware of, it's the formal doctrine that's tied to an agreement to usually a medical intervention, a medical procedure, medications, typically requiring discussion of material risks, benefits, alternatives. So a patient can decide whether they want to proceed. And in many US jurisdictions, they frame material information through it's a reasonable patient lens. What would a reasonable patient want to know to make a decision? Informed disclosure, on the other hand, is the broader transparency obligation, telling patients truthfully, plainly that AI is being used, what role it plays, what guardrails exist, without necessarily running through the full procedure style consent process every time a tool is used. This distinction matters because most AI deployments in healthcare support tools are where the clinician remains the decision maker, and AI itself is not, quote, the treatment. In those scenarios, full informed consent is usually not required, but transparent disclosure is still appropriate. Down the road, we'll assuredly begin to see AI implementation that directly involves diagnosis and treatment decisions, which may necessitate a formal informed consent process. Regardless of how it's framed, disclosure or informed consent, patients usually will view the use of AI in their care as material concern. A 2023 Pew Research Center survey found that approximately 60% of Americans reported some level of discomfort with their healthcare provider relying on AI. AI systems are inherently complex, and in many cases, they're continuously learning. And this complexity, it's a key reason they hold such promise. But it also introduces new and unfamiliar challenges. One concern is the black box problem, which refers to the reality that AI systems' internal reasoning, it's often not visible or even explainable, sometimes even to its own developers. So it's this black box that it's really hard to see inside. And this lack of transparency has important implications. It raises a critical, informed disclosure and informed consent question. Can a physician adequately inform a patient about the risks and benefits of AI supported care if the physician cannot fully articulate how the AI system reaches its conclusions? So, at this point in time, a compelling argument can be made that physicians need not understand the technical intricacies of the AI system, but instead should be prepared to provide a general explanation of the system, the role it plays in the decision making, its limitations, and its risks. From a risk management perspective, the most prudent approach is to err on the side of transparency and disclose the use of AI whenever it plays a role in patient care. To ensure disclosure is meaningful, providers should be able to describe, just at a basic level, as I mentioned, how the AI works, the role it plays, and its limitations. Formal informed consent should be obtained when circumstances warrant it, and it's advisable to view disclosure and consent as really existing on a continuum. Disclosure will generally be sufficient when AI is used as a supportive tool that complements, augments clinical judgment. More robust formal informed consent is likely it's appropriate when a patient becomes material, excuse me, when AI becomes material to a patient's decision making or when it functions in an autonomous or a near autonomous matter. And finally, regardless of the approach taken, practices should consistently document that disclosure was provided or that informed consent was obtained. Clear documentation, as always, remains a critical safeguard for both patient understanding and legal defensibility. As AI becomes more deeply embedded in clinical and administrative workflows, it raises a series of legal questions. Does the use of AI increase a provider's exposure? Or conversely, could failure to adopt AI create risk as the technology becomes more prevalent? How will courts evaluate claims involving AI-assisted decision making? And perhaps most importantly, will AI meaningfully alter the standard of care? At present, many of these issues remain unsettled. Case law is limited, courts are only beginning to confront AI-related claims. That said, looking at existing liability theories and some early litigation trends, we can begin to anticipate how AI is likely to influence medical malpractice claims and also how it will influence expert testimony and overall litigation going forward. In the following clip, Attorney Scott Salter is going to highlight a few of the theories of legal liability that could come into play when using AI.
I think what we're going to see are theories that can range from a true argument for a medical malpractice claim made by the plaintiff, arguing that the decision making was faulty and that they can be held liable just like a physician. There can be other theories, such as a true product liability theory, that the design or implementation of the algorithms was defective. You could also see a different type of professional negligence claim, where it has to do with the input that was placed into the program and an allegation that there was negligent programming on the front end of the AI product. From that standpoint, we'll see these artificial intelligence producers become parts of the lawsuits on a much more frequent basis as physicians are using it more in their practices.
Scott touched on the potential for professional negligence and product liability claims. From a professional negligence standpoint, a plaintiff might argue that a healthcare provider owed a duty of care to use AI systems in a safe and competent manner. If the healthcare provider failed to do so and the plaintiff was injured, then the plaintiff could potentially recover damages. A product liability claim may arise when a plaintiff is injured by a defective AI system. Generally, we can expect these claims will be aimed at manufacture of AI systems. But say a large healthcare system, they may develop and be legally responsible for their own AI-based systems. A breach of contract allegation could arise if a provider fails to use an AI system in accordance with the terms of a medical treatment contract between provider and patient. Fraud claims could arise if a provider or a healthcare system knowingly or intentionally promotes the capabilities of an AI system that can't meet that promised outcome. For example, the healthcare provider might claim that an AI system is more accurate than it's been proven, or that it could be used to diagnose a particular condition outside of its intended purpose. And finally, we can expect to see privacy-based claims from patients who are concerned about their medical information being utilized by AI systems. And we'll review a case a little bit later that provides a bit of guidance on this issue, this third-party authorization issue. Currently, we're unaware of any medical professional negligence lawsuits that involve AI. That said, as AI tools become more deeply integrated in clinical decision-making and care delivery, it's reasonable to expect that such claims are going to come forward. While the timing and the contours of this litigation remain uncertain, AI-related negligence allegations are likely inevitable as courts begin to assess how existing malpractice principles apply in AI-assisted care. AI is most likely to intersect with malpractice claims in one of two ways. First, if AI recommends a specific action or treatment, and the physician either overrides or ignores the suggestion, or second, if a physician follows the prompt or AI software generated guidance, and it's later found that AI was in fact not correct. I just wanted to read a quote from a journal that was published in May of 2023 by Neuroradiology. And the article was quick to establish that while this medical legal framework for AI is still in a relative flux, and this quote I think is great because it really sums up what's going on currently. The ultimate responsibility for a diagnostic or therapeutic decision will likely remain with the physician, who has to validate the results of the CDS, the clinical decision support tool. And this sentiment, it really truly serves as the underlying theme for our current state with AI. Perhaps the most consequential liability question that's associated with the use of AI in healthcare is whether it will ultimately alter the standard of care. As AI tools become more prevalent and increasingly integrated into clinical workflows, courts will be asked to determine how and to what extent AI-assisted decision-making should factor into assessments of physician reasonableness and professional judgment. In the following clip, attorney Scott Salter shares his perspective on how AI may influence standard of care analysis and what clinicians should be mindful of as these issues begin to surface in litigation.
I think the first thing is, as of today anyway, we really haven't seen a lot of lawsuits where either the failure to use or overuse of AI has been a central component of the cases. And I think part of the reason, especially on the issue of whether there's a failure to use AI, is because it's really not that prevalent yet in most doctors' offices as far as using it to make diagnoses or treatment recommendations. But I think we will see a tipping point. There will be a point where the AI becomes consistent enough, where it becomes effective enough, where it becomes prevalent enough in healthcare providers' offices and in hospitals that the majority of healthcare providers are going to be using it. And when we reach that tipping point, I think that's when we'll see for the first time plaintiffs' attorneys pursuing those theories that the failure to use AI is below the standard of care. I think it's important when we see that happen, though, that from a traditional medical malpractice standpoint, a lot of the same components are going to be there. There's going to be an aspect that the plaintiff's attorney is going to have an expert come in and say that there's been a breach of the standard of care and the failure to use AI with that specific patient or under those specific circumstances. I think, though, it's going to be untraditional in a way that for a plaintiff to win on that theory, that if they can prove that there was a breach by not using an AI product, to prove the second half, I think they've got to prove what AI product or products they say should have been used, what the input would have been into those products from the physician on that specific patient, what the output would have been as far as diagnoses or treatments from that AI product, and in the end, that would have made a difference in the patient's ultimate outcome. So I think it'll be a little more complicated, maybe on the causation aspect, but it will still largely be like a traditional medical malpractice case. We are telling physicians now is you are not able to throw away your skill and your judgment in how you care for a patient. If you are using AI as a tool, it's a tool there to augment your care and treatment of the patient, but it in no way obviates your duty to exercise your own independent skill and your own independent judgment in treating a patient.
Some interesting developments to come in that area for sure. So switching off of legal implications right now and taking a look at bias. And to ensure AI systems functions appropriately for all individuals, steps really have to be taken to ensure that systematic errors or distortions in data don't result in unfair or unequal outcomes. For example, if an AI system aimed at detecting skin cancer and it's only trained on images from people with light skin tones, it won't function as intended for all patients. Bias data sets can inadvertently harm patients and expose providers to risk. In terms of legal liability, a healthcare provider will generally not be responsible for the shortcomings of a defective product that doesn't do what it's intended. However, a health facility or provider may be held accountable for clinical decision-making and subsequent results when relying on a faulty AI product. Little subtle there, but it'll be interesting to see how that works out. In 2019, a landmark study published by the Science Journal focused on discriminatorily flawed data that was underlying an AI algorithm. And this racially biased and inaccurate data created a skewed perspective on the acuity level of hospital patients. So this hospital algorithm, it was applied to millions yearly and was found to be assigning the same level of risk to Black patients as it was to white patients. The problem was that Black patients were actually sicker than the white patients at the time, putting them at risk for delayed or insufficient care interventions. So why did the algorithm inaccurately assign the levels of acuity, not giving high enough risk scores to Black patients? Well, the AI was using past health costs to predict and respond to healthcare needs based on the acuity of condition. So overall, unequal access and various barriers to care for Black patients meant that less money was spent on their healthcare needs, not necessarily that those needs didn't exist. Therefore, when the health needs were based on health costs, it led to the erroneous deduction that less money spent on hospitalizations for Black patients meant that Black patients must not be as sick. And this study found that removing the disparity would increase the percentage of Black patients receiving healthcare assistance they needed by almost 30%. Well, the good news, per this study, was that these label biases are fixable once they're identified. And we just need to be careful and purposeful about the data fueling our algorithms. To ensure AI systems in healthcare properly serve all patients, the Office of Civil Rights took a proactive steps to address the risk of bias in these data sets. It's even laid out in Section 1557 of the Affordable Care Act that prohibits discrimination in health programs that receive federal assistance, as you know, on basis of race, color, national origin, sex, age, or disability. And the OCR specifically noted the vast use of these automated decision systems and AI, and they did confirm that AI is included in the definition of patient care decision support tool, which could result in this prohibited discrimination. So they laid out two rules, basically that there has to be review for potential discrimination within a CDS tool, and reasonable steps need to be taken to mitigate the risk of discrimination. The rule noted that covered entities should establish written policies governing how clinical algorithms will be used in decision making and also train staff on the proper use of such systems in decision making. Now, another important topic, HIPAA. So DHHS oversees this significant area of potential exposure with HIPAA. Although HIPAA was enacted long before the advent of AI, its principles, privacy, security, appropriate use of PHI, all apply to AI systems. Any AI system that creates, accesses, transmits information is subject to HIPAA's requirements, regardless of whether the technology is new or highly automated. As AI becomes more deeply integrated into these clinical workflows, you really must evaluate these tools through a HIPAA lens, ensuring that the data access is limited, that there's safeguards in place, and the vendor relationships, the relationships with the AI vendors, are secured to maintain compliance and protect privacy. We discussed the importance of disclosure and transparency when you're being exposed to AI technologies. But important follow-up question is whether a practice must obtain a HIPAA authorization when sharing patient information with an AI system. Well, in most cases, this is not required because it's being used for treatment, patient, healthcare operations, which is a common exception of HIPAA, the TPO, we call them exceptions. And a critical prerequisite of this, though, is that the AI vendor is operating as a business associate and you have a valid business associate, a BAA, in place. So when PHI is shared for TPO purposes under a business associate agreement, separate authorization is generally not required. For example, if you're, using an ambient device and it's transmitted to a vendor's platform, it's usually not necessary, this HIPAA authorization, because it's being used for TPO. But what if the patient information is being used to train or improve an AI system? There's a strong argument that this is outside of TPO, and also that a HIPAA authorization may be the safest way to ensure compliance. And there's additional layer, though, to look at is HIPAA only applies to PHI, which is by definition can be linked to a specific individual. So if the AI system is designed to properly de-identify the data it collects, which most, I believe, are, such that this information, it can't be traced back to a certain individual, then it really falls outside of HIPAA altogether, so that authorization would not be needed. And let's look at a case that talks about this very issue, this role of proper de-identification. And in this case, there was a research collaboration between the University of Chicago Medical Center and Google. The university gave Google anonymized patient medical records to implement AI-driven predictive health models. Well, a former patient sued Google and the university alleging violation of HIPAA. And HIPAA, it doesn't provide a private cause of action, so one person can't sue as a HIPAA violation. But they use this violation to allege a violation of, like, a breach of contract. And the contract was the privacy agreement he signed with the hospital. So the district court dismissed the case, finding that the patient did not have standing to sue because they didn't suffer any harm. They had no basis to sue. And the Seventh Court affirmed or agreed with that dismissal, saying that the patient had not suffered an injury as a result of the disclosure of the medical records. The court noted that the medical records had been stripped of all direct identifying information, and the only way the patient could be identified would be if someone compared his medical records to his geolocation data. And they found that this was unlikely to occur, so therefore the patient lacked standing to sue because all that information had been de identified. So, from a HIPAA perspective, if the information is properly de identified and can't trace back to an individual, then HIPAA doesn't apply. And this decision indicates that patients will need to demonstrate actual harm when their properly de identified information is utilized by an AI system. So, that's good news for AI systems and people who use them. So just taking a quick look at HIPAA-related reduction strategies, make sure that, while most of these use these TPO exceptions, it's still required when data goes beyond those purposes. Review your business associate agreements and understand how the vendor will access the information, and including any model training or use secondary uses. And another thing to look at is in these encounters, a lot of times patients are discussing very personal things, home, current work, school environment, stressors. It's unclear now, when this information gathered by AI may be shared with an outside entity, including state and federal governments. And when possible, use AI systems that de-identify patient data, and because this materially reduces the risks, regulatory exposure, breach risks, but the practices should verify the methodology and safeguards that the vendors use. And remind staff that AI integration does not relax HIPAA obligations. Make sure that access, it has to be what is reasonably necessary for the function, reducing both privacy risk and liability. And the last big topic, AI chatbots. And they've moved from a typical online customer service solution to an active global player. It's no small issue. A 2024 study found that 2/3 of adults use AI, with 1/3 doing so at least weekly. 1 in 6 use AI chatbots for health advice, and that rises to 1 in 4 when we're talking about people under 30. This frequent use of chatbots emphasizes the importance of prioritizing and addressing safety and ethical concerns. ChatGPT, it's OpenAI's well-known source of AI-generated information. And if you had to guess how many people use ChatGPT each day for health-related questions, what would you predict? Maybe 5 million, 10 million? Well, ChatGPT is asked for health guidance by 40 million people per day. 25% of the estimated 800 million users around the world turn to this AI source for healthcare-related answers. And 7 out of 10 of these conversations occur outside of normal business hours for physician practices. Utilization of AI for health answers is higher in the least populated areas or hospital deserts, which is defined as usually a 30-minute drive to a general or children's hospital. There was a lawsuit was filed in 2025 against OpenAI, alleging that a 16-year-old from California hung himself at home after a months-long interaction with OpenAI's ChatGPT. The lawsuit alleges that OpenAI bypassed critical safety features needed to pick up the dangerous comments by the teen. The chat box encouraged the minor to end his life, dissuaded him from discussing his thoughts with his family, even helped him design a noose, and planned the detailed steps. The complaint states that OpenAI's system tracked but never tried to stop the predictable pattern of a teenager's mental health decline, and in fact, even offered to draft his suicide note. Despite hundreds of real-time opportunities to discourage the path of self-harm, the chatbot failed to do so. And this wasn't a case against a healthcare provider, and it really centered on deceptive business practices, negligence, and design defect. However, it can show what could easily become a medical malpractice case if an entity or professionals were utilizing a chatbot, maybe a homegrown, unvalidated bot, for specifically mental health therapy or any other advice. And sadly, this isn't the one of a kind, and it really highlights the dangers of launching an AI product without safeguards. Another concern about the availability of chatbots is the constant exposure to misinformation. It was bad enough when a patient would Google systems and come in and, have self-diagnose themselves, but these chatbots take it to a whole new level. Physician practices really should stay diligent about where their patients are getting information, what's informing their opinions, and what resources they utilize. And according to a survey by the Mesothelioma Center in November 2025, 1 in 3 Americans admitted that if an AI tool suggested that their symptoms were not high risk, they would skip their doctor's appointment. Over-reliance on AI tools can delay time-sensitive diagnosis and care. But the good news, I always want to focus on the good news, is that 80% of those in the survey trust their doctor the most. And so don't be afraid to ask patients about if they're using chatbots, where they're getting their sources. Physicians and their staff will benefit when they expect the consequences of this medical information and are prepared for questions and pushback. It's important to show patience during these conversations while leaving a defensive posture behind. Physicians need to understand the root of medical misinformation and the way it affects patients. Compliance cannot be forced, but physicians must persist in discrediting falsehoods to keep patients safe and healthy. So we've discussed what AI is and how it's being used, some potential liabilities. But now let's turn to just a couple situational considerations you may encounter when utilizing AI in your healthcare setting. And we have one last clip from Scott Salter where he discusses physician documentation when AI is used as a clinical
A
support assistant
physician
tool.
does need to have documentation in their chart of the role that AI may have played in their decision-making process. In that regard, if a physician is using an AI product and gets a certain diagnosis or gets a certain treatment plan, they need to take that information if it's confirmatory of what their own independent judgment is, and document in the chart simply that they've used the AI product and that it confirms what their diagnosis is or confirms what the recommended treatment plan is based on their skill and their judgment in the process. If they disagree with what AI has recommended, then they need to document that as well and put in their documentation the reasons that they are disagreeing with that diagnosis or disagreeing with the treatment plan for that specific patient.
And I did want to mention what to do if a patient opts out of a clinical support tool. So you just want to have that conversation with them, kind of like an informed refusal. Go into what the risks are, what the role of AI would play, its limitations, and emphasizing that clinical judgment remains central. If they still refuse, that preference should be documented in the medical record as long as details of the conversation. And from a clinical standpoint, if a physician remains obligated to provide appropriate care using the best available alternative that doesn't involve AI, even if it's less efficient and less precise than the AI supported option. And this all should be explained to the patient and documented. And this ensures that the patient's refusal is truly informed and the physician has met their disclosure obligations. Importantly, if a patient's refusal of AI, it doesn't dissolve the clinician of the responsibility of care, nor does it require the clinician to provide care that falls below the standard of care. So if declining the AI would materially compromise patient safety or leaves no reasonable alternative, that issue should be discussed candidly with the patient and documented. I just wanted to point out, in interest of time here, I'll go through these quickly, but there are a couple of resources. The Joint Commission has a resource that you could obtain, or you can go directly there by scanning the QR code there on AI. And AMA has a really great toolkit that has a sample policy and lots of hints as far as implementing and managing AI systems. So again, that is available by scanning the QR code. And again, you will be getting a copy of these slides. And just wrapping it up as we close, I think it's just important to acknowledge that there's many questions around AI that remain unresolved. Regulatory standards, they're still evolving. Case law is really limited. So, but waiting for a perfect clarity, however, it's just not an option because AI is here. And we're already seeing physicians encountering challenges on the daily. AI should be reviewed as a clinical support tool, not a replacement for medical judgment, accountability, clinical reasoning, patient-centered care. They don't transfer to an algorithm. And ultimately, physicians remain the final decision makers. I'd like to thank you very much for hanging in as I went a couple minutes over here. Thank you for your time. Again, the slides will be sent out. My contact information is at the end of the slide. So if you have any questions, you can reach out through your medical society or you can reach me directly. Again, to get the CME credit, you do need to complete the survey. You can either get the survey by scanning the QR code or it will be emailed to you. And here is my information, my direct line. If you need something urgently and I'm not available, our hotline is staffed from 5 a.m. to 5 p.m. every day, and someone is always available to answer your questions. I think that is it for me. Thank you very much for having me, everybody. I don't know if Allison or Janice, you wanted to chime back in, or should I
Sure, I'm not
just?
sure where Allison went, but
Okay.
thank you everybody for joining us this afternoon. We hope you took some important vital information back with you to your office and to share with the colleagues. Again, like Katie said, we will be sending out an email to everybody, and we look forward to having you join our next event. Please stay tuned. Visit our website at www.sbcms.org for any additional information and our event listing. We hope you have a wonderful afternoon. Thank you. Goodbye, everybody.
Thank you. Goodbye.